We'll keep searching through the darkest day for every soul that's lost or gone. We'll fight until the break of dawn. American justice stands so tall. We won't rest until we found you. Oh, for all the lost, both near and far, you're in our hearts. You're who we are. Through the nights and through the pain, we will say your name again. Every step we take is true as we continue to search for you. American justice stands so tall. We won't rest until there is justice for all. For all the lost, both near and far, you're in our hearts. You're who we are. We will continue to pray until you're home to stay.
Hello, everybody. Hey, Ben. Hey, Tambourine. And hello, anybody else that is either lurking or watching this on replay. So we made really good progress yesterday. Going through these court papers. We're on page 81 of 113. It would help if I bring my mic a little bit closer. Hi, Cheryl. Hi, Amy. So hopefully, if we continue with the progress, hopefully we won't need a part 5. But I'm thinking we're probably going to need a part 5 because I got a feeling I've got a lot to say on this. I have no clue yet. So let's just hop right into it and get this read because I'm officially on the fence. I started out, I was fully, Richard Allen was guilty. I'm now officially on the fence. So I don't know how this is going to end up. Let's see if I get to the other side today. So we left off with D. Even if the court finds Allen's statements voluntary, they are a product of an unconstitutional detention. That one I don't know about. I don't know if his detention was unconstitutional as in he was in the prison, or do they mean because he was in solitary for 13 months? Let's look and see. Allen's prolonged solitary confinement violated Article 1, Section 12 and 15. Indiana courts are constitutionally bound by the basic concepts of fairness that are frequently identified with due process in the federal Constitution. Article 112 guarantees for every person, for every injury done to him in his person, remedy by due course of law. Here, Allen was sent to solitary for quote unquote safekeeping without even a hearing or a notice. I thought they had a hearing with the first judge. I thought they had the hearing, the safekeeping hearing. His lawyer wasn't there because his lawyer wasn't notified, I thought. I might be wrong. Even when his attorneys informed the court of his dire condition, the court refused to set a hearing in violation, although the court eventually held a hearing on June 15th of 2023. By that time, the damage was done. Fairness protections in criminal cases are found in different Indiana constitutional provisions. Just as pretrial punishment violates federal due process, it violates the Indiana Constitution. Indiana is one of the 6 states protecting citizens from unnecessary rigor. the framers wrote, "No person arrested or confined in jail shall be treated with unnecessary rigor." Typically, this provision requires a prisoner suffers severe mistreatment. Recognizing this provision applies to solitary confinement, the Indiana Supreme Court stated. So, prisoner suffers severe mistreatment. Trigger warning. I know I've showed it before. I'm going to show it again. I think not checking on a man who's banging his head to the point that he has two swollen black eyes and swelling and blood on his head, and not checking on that prisoner for over an hour constitutes prisoner suffering severe mistreatment. Hey, Mariska. That's right, Melissa. They didn't tell his lawyer of the hearing. That's what I thought. It's like, I'm pretty sure they just violated his right there. But, I mean, I don't know. I think that would be prisoner suffering from severe mistreatment. I mean, maybe I'm wrong, but we'll see what they have to say about it. The very essence of punishment and the sole use of the prison walls is the confinement of the convict within them. Humanity indeed forbids, as unnecessary rigor, that his confinement should be absolutely solitary, or that all his natural and civil rights should be temporarily alienated. Here, Allen's treatment rose to the level of unnecessary rigor. Rigor is the act or instance of strictness, severity, or cruelty. When Allen started suffering from confusion, memory lapses, paranoia, and bizarre behaviors, there was no longer a risk. He could not handle the harsh conditions of maximum security solitary. It was a reality. The strictness, severity, and cruelty of his confinement is evident on video, where he is screaming in fear, confused about where he is, unable to respond, and drooling and self-harming. Like I said, banging his head on the wall. The rigor was physical too. Allen lost 40 pounds and was unable to care for himself. He was tased. His face was black and blue at times and bleeding. I just showed proof of that. He was poisoned by fecal matter and toilet water. Isn't that by his own doing, though? Like, he chose to eat his own poo-poo, okay? Nobody made him do it. Nobody made him drink toilet water. Now, I get it. He was clearly in psychosis at this time, but he kind of poisoned himself, if that's how you want to put it. Just my thought there. Indifference to his catatonia is shown where medical staff discusses blood pressure and cholesterol with a vacant Allen. The psychological and physical pain was unnecessary. The Indiana Department of Corrections could have transferred him upon deterioration, as policy requires. Even an isolated infirmary cell would have been better than the whole designed for punishment. Likewise, the court could have moved him when the court learned of his dire condition. Facts. I feel a lot better. I think the medicine is finally, I mean, coughing still hurts, but other than that, I think I'm on the mend. Now, just to get rid of the infection and the inflammation would be great. Poor guy. Cruelty beyond belief. Yes. Cruel and unusual punishment. Exactly. Violates his 8th Amendment. I think they violated just about every amendment they could. Mariska. He should have been restrained in order to prevent self-harm. Yeah, right. Not sit there and watch him do it for over an hour and then just not give him medical treatment. That was nuts. Number 2, the constitutional violations require suppression. Over 150 years ago, I am not even going to try to pronounce that. Dostoevsky. Oh, forget it. I'm going to butcher that. Wrote, the degree of civilization in a society can be judged by entering its prisons. In 2015, writing about the effects of solitary, Justice Kennedy hearkened to this quote, noting there is truth to this in our own time. Applying the exclusionary rule to these constitutional violations would deter abuses within our prison system and law enforcement, protect judicial system integrity by showing it condemns such conduct, and protect the human dignity of those unable to make bond while awaiting trial. In parentheses here, it says excluding confession that was a result of physical abuse and solitary in part under Article 1, subsection 15. Indiana has a robust exclusionary rule relying on Article 1, subsection 1114. Indiana adopted the exclusionary rule long before the Fourth Amendment exclusionary rule applied to the states. Under the exclusionary rule, to determine whether a statement is a product of a illegal detention, the court must ask if the statement has been come at by exploitation of the illegality, or instead by means sufficiently distinguishable to be purged of the primary taint. The court considers one, the time elapsed between the illegality and the acquisition of the evidence. So he was in solitary, I think, 4 or 5 months before he started confessing. Not supposed to be in there more than 30 days. The presence of inventing circumstances, and 3, the purpose and flagrancy of the official misconduct. First, Allen's statements occurred during the illegality of his detention at Westfield Correctional Unit. Second, there were no intervening circumstances. Again, there is a well-known connection between solitary confinement and psychosis or delirium. Third, the constitutional violation was flagrant because the Indiana Department of Corrections violated its own policies for keeping Allen safe, and the court and prosecutor refused to help when Allen's attorneys warned of his deterioration. Even if this court finds that Allen's statements were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. The trial court erred by denying the motion to suppress. The error was not harmless, right? Because remember, when the state did their response, it was a harmless error. Harmless error. Nothing they did was a harmless error, in my opinion. Hey, Peace Spice. Was he in psychosis? Yes. There are reports he was feigning symptoms. Peace Spice, it says in here, and it gave back here. Let me just pull it up. Control F. Feigh. Right? G. Let's see. So each time Allen confessed to Dr. Wallace, she said he was not delusional, hallucinating, or psychotic. Although Allen expressed confusion and memory gaps, she suspected he was feigning or acting bizarrely. She at times labeled him as feigning for secondary gain. Although Walla noted concerns about feigning, she diagnosed psychosis and suspected incompetence and overmedication. Now, there was, I don't know why it's not pulling up. Maybe it was malingering, which is basically the same thing. Dr. Westcott found no malingering, aka feigning, both of them mean faking, through objective testing. So there's that. hope that explains it. So let's go back to, I think we were on 85. Yes. So, hello, Mike. Did you see that I responded to you? You were wanting to use this. If you want to email me, it's scrolling across the bottom. I will send you both his appeal and the state's response if you want to email me, Mike. I'll be glad to share with you the entire document as a whole if you want it. Just shoot me an email. So we read that. The error was not harmless. Yes. Okay, let's close that. Before a federal or state constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. No piece of evidence may have greater sway over a jury than a defendant's confession. The erroneous admission of statements to Dr. Walla alone was prejudicial because they were a large part of the state's case. They were. They harped on it a lot. The prosecutor particularly concentrated on Allen's May 3rd statement, arguing that Allen knew a fact only the killer would know, and that was the white van. The confessions also countered Allen's confident and unwavering pre-solitary protest of innocence. 3, the court denied Allen his right to present a complete defense. Yes, they did. To explain the scene and impeach the investigation. Yes, they told him no third-party defense at all would be admitted. The 14th, sorry if you guys heard that, that's my cup. The 14th Amendment guarantees a defendant the right to a fair trial. The amendment's due process clause places significant substantive limits on state power, prohibiting its arbitrary exertion and guaranteeing criminal defendants a fair opportunity to defend against the state's accusations. For an opportunity to be fair, a defendant must be permitted to confront and cross-examine witnesses and to call witnesses in his or her own behalf. These overarching principles operate in tandem with the Sixth Amendment, which similarly guarantees criminal defendants a meaningful opportunity to present a complete defense. Although trial courts have broad discretion in conducting trials, its discretion has constitutional limits. That is, the courts may not infringe upon a weighty interest of the accused through decisions that are arbitrary and disproportionate to the purposes they are designed to serve. As explained more fully below, the trial court made several reversible errors under the rules of evidence and Indiana's trial rules. In many instances, these decisions violated the Constitution as well. Now, I looked up, because I don't know how appeals work. So I'm not a lawyer. So I looked it up. And from what I could gather, now, I'm not 100% sure here, but from what I could gather, you go to, when you make an appeal, you appeal to the appellate court. And then I think if you don't agree with them, you can appeal to the Indiana Supreme Court, I think is how it works. Mike says, thanks. I do like hearing your view on the documents, etc. I mean, hey, I'll send you whatever you need, but I don't take my word for it. I was honestly on, he was guilty. He deserved a new trial, but he was guilty. I am now on the fence of whether or not he's guilty and still think he needs a new trial. So I don't know. I think this makes a lot of valid points. I think the question is, was he in psychosis when he made the admissions of guilt? So according to this, yes. But some of them were before he was diagnosed into psychosis and some were after. But how much can we rely on what Dr. Wallace said when she violated his patient doctor privilege? She destroyed her notes. She was on Facebook commenting in groups and in chats on YouTube. commenting while she was treating Alan. So how much can we rely on what she says? She lost a lot of credibility, and I think she deserves to have her license taken, in my opinion. Ben, I don't think he was. No. So, like I said, some of them he was, some of them he wasn't, if you go by what the state says and what Dr. Wallace says. So A, the standard of review. While this court assesses claims relating to admitting or excluding evidence for abuse of discretion to the extent those claims implicate constitutional issue, this court reviews them de novo. Errors in the admission of evidence will be disregarded as harmless. How can you, I don't understand how they could say, well, you weren't able to put on a defense or you weren't able to put in evidence, but that's harmless. No, it's not. It literally, you took away his right to present a defense. If its probable impact on the jury in light of all the evidence in the case is significantly minor, so as not to affect the substantial rights of the parties. Okay, I think showing that somebody could have clocked in for one of the other people or one of the other people that they wanted to blame in the first place is posting pictures very similar to the crime scene and has changed his story multiple times. Factory reset his phone. You've got another one that ask an officer, if I spit on one of the girls, can you get my DNA from that? Like, how is that minor? Or how does that not change the impact to the jury? Someone explain that to me. I mean, it makes no sense to me at all. It was very harmful to his defense. I agree. Totally decapitated his ability to defend himself. Yeah, exactly. They literally took away his ability to defend himself. Because when they say, oh, well, the white van, or he was clocked out at such and such a time. Okay, well, we can prove he wasn't there. Well, did you look at the video? Videos were erased. Videos were deleted. Videos weren't even taken of some statements. It's not harmless. That word pisses me off. Harmless error pisses me off. Because in my opinion, it was not harmless. Maybe I just am too invested. I don't know. But I don't think it was harmless at all. I think it seriously hurt him. So let's continue before I go off on a long rant. But when the error is constitutional, the standard is higher. Generally, before a federal constitutional error can be held harmless, the court must be able to declare a belief that it was harmless beyond a reasonable doubt. Beyond a reasonable doubt. If I'm sitting here as a reasonable person and I'm going, that gives me doubt, then you have not proved that it was harmless beyond a reasonable doubt to a normal person. Having two sketches gives reasonable doubt, right? That gives reasonable doubt. Because neither one of them really look like him. You got one guy was said to be in tan and had fluffy hair. I mean, how much more reasonable doubt do you need? He was marked cleared. You didn't take his phone. You didn't really do a proper interview back in 2017. But all of a sudden in 2022, you think this is the man and he's got to be guilty. Why? Because he was the man that you want to put on the bridge. That's why. So I don't remember where I was at. Oh, beyond a reasonable doubt. Yeah. So the court committed reversible error by excluding Blair's sketch of Bridge Guy. So the April 2019 sketch, this is Blair's depiction, or no, July was Blair's, and that was Carbog's, I think. Right, Ben? The first one was Blair, the second one was Carbog, or do I have that backwards? So at trial, the court prohibited Allen. Oh, guess it helps if I put it up, right? Hey, Kelly. At trial, the court prohibited Allen from using Blair's sketch of Bridge Guy. This decision violated our rules of evidence and denied Allen his constitutional right to present a defense of mistaken identity. Evidence is relevant when it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Now, I don't know how I feel about this because sketches, those are an investigative tool, right? They're not evidence. So I don't know, because even the state didn't bring in the sketches. So I don't feel like bringing in the sketches would have followed the law because they're not evidence. They're an investigative tool, just like a polygraph is. So I don't know that bringing in, yes, it would create reasonable doubt. Yes, I get they could sit there and go, okay, well, isn't this who you said it was? And isn't this the sketch that you had made? And you gave it a 10 out of 10 on accuracy, but this doesn't look anything like him. I get what they're getting at. I understand it, but I don't think it would be allowed. That's right. Blair was the first sketch, but it was the second sketch released. Yes. Okay. So young bridge guy is Blair. Older bridge guy was Carbaugh. Now, one was released in July of 2017, one in April of 2019. However, young bridge guy was technically the first one drawn, whereas bridge guy photo was the second one drawn. It gets really freaking confusing to try to keep all this straight. But again, these are investigative tools. So to me, it falls in the same kind of area as a polygraph. Like, I don't see how you can. I mean, I get what they're saying. I don't know. I'm going to have to think on that one because I get what they're saying. I just don't think bringing in the sketches would have been allowed. Hi, little black bear. Hello, Miss Bell. I agree. I'm the same. Well, see, I'm not. The ones describing the defendant would be eyewitnesses. Yes. So Blair and Carbaugh. So Blair seen this young bridge guy photo, this young bridge guy on the first platform when she was walking on the trail. And Carbaugh was the muddy, bloody guy, right, Ben? Do I have that right? I think so. There are so many players in this. I'm having a hard time at this point. It's been so long ago keeping track of who's who. Those sketches could be used in the defense to give reasonable doubt. You think so, Mariska? You sure? I would have to look that up. I would have to look up and see if you can use a sketch at all, because I don't feel like that would be allowed. I don't feel like that would be allowed. So hold on a minute. Tell me, guys, if my avatar changes, because for some reason it wants to be a pain. Here, I'll put it on Nick. Okay. Yes and yes. Melissa, were the jurors shown the sketches? No, not that I remember. But I wasn't in the courtroom every day. So I can't say yes or no for sure because I wasn't in the courtroom every single day. I was only in the courtroom, I don't know, 3 or 4 days. So I can't really I don't really know. Like, I can't say for sure. But I don't think so. I don't think they were allowed in. I think that they were told no, that they couldn't bring them in. So that's what you thought they weren't shown? No, I'm just struggling with the thought of putting the sketches in as evidence because they're not evidence. They're an investigative tool. I don't know. That bothers me. I don't know what to think, honestly. I really don't. I don't want to speak out of turn because I don't know for sure. I'm not a judge. I'm not a lawyer, but I don't think sketches would have been allowed in. And there are a lot of inconsistencies. Too many. And there's too many violations of his rights. The avatars of my son. Good. Okay. Well, I had me on there and I went to look and see because for some reason, sometimes the avatar, like, it's just a white blank thing. And it was. So I changed it. I don't know. It doesn't like me on screen, I guess. My son will have to work. He's just going to do it with us, I guess. The witnesses that described and saw them should have been brought in to identify or refute the defendant as bridge guy. They were. Harbaugh and Blair, I think, both testified, but I wasn't in trial. I wasn't in the courtroom when they did. I would have to go back and watch probably either Andrea Burkhart or Lawyer Lee to see. But I'm pretty sure both of them testified. But to my memory, nobody said, is the defendant who you saw? Like, that would have been the perfect opportunity. Well, is the man sitting here at the table, is that who you saw that day? Because to my recollection, that was never done to any of the witnesses. Again, it's been a while, but I'm pretty sure that was never done, if I remember correctly. Yes, but if defendant is able to use a lie detector test in his defense, if you do it stipulated, yes. When my ex-husband had to take a lie detector test, it was a stipulated lie detector. If he passed, he could use it in his defense. However, if he failed, then the state could use it against him. He failed with flying colors. I knew he would. Anyway, I digress. But they didn't give him a polygraph that I remember or that I ever remember hearing about. But I'm pretty sure that that Gull said the sketches couldn't come in. I'm like 98.9% sure that Gull said the sketches couldn't come in. My law professor just told us in a lecture. Yeah, I know they can if they're stipulated. Melissa, do I have the trial transcripts? No, as I am not able to pay that much money for them. There's just no way. I mean, that's a lot of money. I have, let me pull it up here. Go here. I have a memorandum that he did. I have the appellate's brief, the appellee brief, the motion to strike, the confidential supplemental exhibit 1, 2, 3, 4, 5, and 5, the notice of filing for the supplemental exhibits, and the reply to state's response to the motion to preserve evidence. And then I have, let me look here because I'm pretty sure I don't, but I'll double check it. Let me go there. Nope, that's not where I want to go. Go here. So then I have the Ricky Davis letters. I have crime scene photos. I have several things, but I don't have the trial transcripts. I have lots of stuff, just not the trial transcripts. Although I could reach out and see if a certain person does, and see if she would be willing to share them with me, because she might. But I don't know. Okay, back to this because I'm getting off on a. What's that? Try that link. Oh, hold on a minute. Doop de doop de doop. Go here. Make me open up a whole nother screen, Ben. There. Come on, pop up. Okay, cool. Heck yeah. So those will download. Thank you, Ben. You are awesome. Hello, No Mercy. Welcome in. Why is... There it is. Jeez, oh, Pete. Okay, my computer's being super slow now. Okay, so back to this. Let's see, where did I leave off? A court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Let's see what they say. Maybe they go into it. So Blair's sketch proves she did not see Alan on the bridge. Blair did not identify Alan in court as bridge guy, but according to the prosecutor, Blair must have seen Alan on the bridge because Alan told us he went to the Monon High Bridge and out to the first platform, which is exactly where Blair saw bridge guy. Blair's sketch shows Alan looking nothing like the person that Blair saw. Just 3 days after the murders, Blair met with sketch artists and described the man she saw on the bridge as white, about 20, medium build, and having curly brown hair. An artist created the following sketch based on Blair's description. There it is. This looks nothing like Alan. At the time of the murders, Alan was short, 44 years old, with closely cropped hair. Blair's sketch also shows that she and Carbaugh saw different people. The state's timeline for the murders is dependent upon Carbaugh and Blair seeing the same person, and the prosecutor told the jury that every eyewitness is adamant the person they saw was bridge guy. There's no doubt in their minds, but Blair's sketch disproves this claim. Carbaugh, like Blair, made a sketch. When Blair saw it, she described it as wrong and not who she saw. So Blair's sketch impeaches the investigation and shows law enforcement bias against Alan. For 2 years, law enforcement circulated Carbaugh's sketch without it yielding a single arrest. So in April of 2019, the Indiana State Police released Blair's sketch, declared it represented the face of Bridge Guy, and announced that Blair and Carbaugh did not see the same person. After Alan's arrest, the story changed, and the jury was told Carbaugh and Blair saw the same person. Blair's sketch was reliable and probative of Bridge Guy's identity. Blair contacted law enforcement the day the girls went missing, and it was very clear to her she saw Bridge Guy. 2 days later, she developed her sketch with an artist and a book of facial features. She stated her sketch was a 10 out of 10 accuracy. Remember, this is the young Bridge Guy sketch that she's talking about. In 2019, she met with law enforcement repeatedly and she reaffirmed her confidence in her sketch. She insisted that she could identify Bridge Guy if she saw him. Then why in court did you not ask her, is the man sitting at the defense table the man you saw and identified as Bridge Guy? Wouldn't that have put it to rest? Was this filed in the Supreme Court of Indiana? This is the second appeal. No, this is his first appeal, and it's with the appellate court. I think some creators were able to get them for free after the appeal lawyers requested them. Maybe. Hey, I'll have no problem looking at them after this live. I doubt I look at them right now. We may have to do another live and just go through trial transcripts. Maybe have Charmaine or somebody up here and we can read through them. How did the defense not ask Blair if Alan was, in fact, the guy on the bridge? Right, Mariska? Okay, you get to cross-examine this witness. Ma'am, is that the person you saw? And point to Alan. No. No more questions, Your Honor. It would have been that simple. Why not do it? No one was able to say that he was the bridge guy. Exactly. Yes, on cross. Hey, Root. It's all right. It's a lot, Melissa. They are big files. Yeah, I seen that. I'll have to, like I said, I'll have to go through them later. I downloaded all of them, but that doesn't necessarily mean that I'll be able to read them right away. I don't. How on cross do you not just say, is that the guy you saw? To both of them. Ask Blair, ask Carball, is that the guy you saw? Now, I've been told, and I don't know for sure because I've never seen a picture of him, but I've been told, I'm not going to say by who, that Elvis Fields matches the young bridge guy sketch. I don't know how much I believe that, but the point is, let me pull it back up. The point is, this young bridge guy sketch looks nothing like Alan. Nothing. Wrong facial shape, wrong ears, wrong hair, wrong eyebrows, wrong eyes. I'd say wrong nose. I'll give them the lips. Huge. Yes. Like at this point, I am just about to hop off the fence. Like I just don't. I don't get it. It's really starting to really piss me off. It really is. Blair's sketch is not hearsay. Indiana bars the use of out-of-court statements for the truth of the matter asserted unless the statement falls within the exception. Here, Blair's sketch was not a statement, although Indiana has not reached the issue. Other courts hold that a sketch is a functional equivalent of a photograph. No statement is involved. Don't know how I feel about that one though. The sketch is not hearsay. A statement is not hearsay. The declarant testifies and is subject to cross-examination about a prior statement, and the statement is an identification of a person shortly after perceiving the person. Agreed. I can give them that one. I can agree with that. They should have been able to say, is this the sketch you had them make? Yes. Is that the man you saw? No. End of story. I'll even give you up to 5 questions if you want. This is one of those times I would look at somebody, you get 3 guesses and the first 2 don't count because you know what they're going to say. Like, it just, how do you not ask? I mean, I know the judge said they couldn't, the sketches couldn't be brought in, but how do you not ask the person on the stand, on cross, is my client the person you've seen? That is what bothers me the most. So let me catch up in chat here. I went on a little rant, sorry. There are so many points at every stage of the process that they trampled on his rights. Every chance they got. Every chance they got. I wonder why they didn't do a lineup for the witnesses when they had Alan as a suspect in the early days. Well, that's the thing, Mike. So Doolin, who is a DNR officer, by the way, went out, met Alan in the parking lot of, I believe, the grocery store, and talked to him and asked him, was he on the trails that day? What was he wearing? And what was he doing? And what the time frame was, right? And he's like, I don't really remember what I was wearing. I could have been wearing a Carhartt. I could have been wearing a hoodie. I went out to the first platform. I was looking at the fish. I parked at the old CPS building, all that. Then they marked him as cleared. So for the next 5.5 years, until this file was rediscovered in a desk drawer and realized it was mislabeled. So many chances. So, I would have, okay, give me your phone right then and there. Give me your phone so we can look at it. Because then when they went and searched his house, there were a ton of phones. I think there was something like, I want to say 17 devices found. And the only phone missing was the phone from 2017. Like, there were so many missteps in this investigation and everything else. Yes, Mariska, it's beginning to make me seriously sick to my stomach. Welcome in, Olive. Spin says the problem for the state was that Alan was a suspect until 5.5 years after the crime, right? And by that point, they had lost evidence. They had recorded over evidence. They had trashed evidence. They hadn't even ran the hair that was in Libby's hand for DNA until trial. I mean, Richard Allen is innocent. I'm about to jump on that side of the fence, Marie. I'm seriously close to jumping off the fence that I'm sitting on to that side. Are you saying the sketch was used as evidence? No, they didn't. They weren't allowed. The sketch was not allowed in, according to Judge Gall. And I don't remember the exact reason she gave. In the early days, he was not a suspect. No, they looked at him, marked his file as cleared, put it in a desk drawer. 5.5 years later, they're like, oh, this doesn't belong here. Who is this Alan Whitehead guy? And why is it marked cleared? And then they're like, oh, let's go search his house. It was a circus led by blind monkeys. All of it was not used in court now. I'm meaning when they realized their slip up. I don't know. Because they're stupid. I mean, literally, this was the blind lead. Mike, listen. The girls were covered with branches. So the one thing that any law enforcement or layperson knows both the killer touched and the victim touched is the sticks that are laid over the girls. They get to the scene, they remove the sticks off the girls and kind of place them off to the side and say they have no evidentiary value. Like 2 weeks later, they go back and they're like, yeah, we were wrong. We're going to go collect those sticks. Seriously? Like, literally the blind leading the blind, led by a blind monkey. Mike Allen's appearance changed a lot in the 5 years. I don't think they ever considered a lineup. Okay, so hold on a minute. We are not going to get through these files today. We're not, because I am getting sidetracked. People are making me sidetracked. And that's okay, because we've got to talk through this. So, well, let me remove this. So, okay. So, let me do that so I know where I was at. Okay, so Young Bridge Guy is the first sketch. Okay. Old Bridge Guy was the second sketch. Old Bridge Guy was the first sketch released to the public for like 5 years. I don't know, 2 years. Yeah, 2 years. So then 2 years later, they're like, yeah, let's release the first sketch that was done. So they held a press conference and they released Young Bridge Guy. Okay. So this picture here at the very end, that is Alan's mugshot. Okay. Now I'm going to show you what he looked like in, I believe it was, I think it was still February. I'd have to go back and try to remember and find this, and I don't know where I could find it. Anyway, this is what Alan looked like within weeks of the murder. Now, after the girls were found deceased, it was, I don't know, 3 or 6 months later, Alan decided he was going to check himself into a mental hospital. Okay. But this is what Alan looked like. Now, the reflection you see is his wife, Kathy. She snuck up on him. He was playing on his phone. This was a video that was on her Facebook. It's since been taken down, so I don't know if I could go get the actual video or not. And I wasn't smart enough back then to actually record stuff like I do now. So she snuck up on him. He had on a blue Carhartt type of jacket. I can't say it was a Carhartt, but it was like a dark blue jacket of some sort, right? He was playing on his phone. He realized she was there. He stopped playing on his phone and he gave her this look. This was within weeks of the murders. So that's what he looked like in 2017. And this is what he looked like when he was arrested. Now, somewhere, don't know where, and I don't want to go looking for it because it may take the whole stream for me to go find it. But there is a picture, and Ben, you know what picture you're gonna know what I'm talking about. There is a picture of Alan and his wife sitting in the bar in front of the Bridge Guy poster. I don't have the one from Tennessee. However, this is not a good picture by any means. Okay. It's not. No, don't want to remove that. Dagnabbit, do what I want you to do, please. Ben, can you send me that one? So let me put that over there. Stop screen, share screen, window. Uh-oh. Do it this way. Remove that. Add there. Oh, I'm not ending. So, let me make this weird. So, like I had said before, so when they realized it was Alan, I went on his daughter's page, which led me to the mother-in-law's page, which led me to this photo in Chicago. And it was a family trip in Chicago, and that is Kathy and Richard Allen, November 15th of 2027. Can you recognize the cap that's on his head? It's kind of similar to what's on this guy's head. I mean, I don't know. I am so conflicted at this point on whether or not this man is actually guilty. And I never thought I would get there. I really didn't. To me, Richard Allen looks like Bridge Guy based on the video. Right? That's where I was at Peace Vice too. But now after reading all of this and actually digging into it, could he have just been an accomplice? Like, I don't know. At this point, I just don't know. But I do know if I was on the jury, I wouldn't be able to convict right now. I would make it a hung jury if I was on the jury. Working, I don't get online much anymore. I know, you're never here. Piece of ice. All the suspects over the years, he looks the most like Bridge Guy for sure. Yes. Yes. I'm going with the Wiccan child sacrifice ritual. Very possible. Very possible. Oh, I'm not going to end it. Not for a while. I've still got at least an hour. I need to go to the barn unexpected. That's okay. Take your time, Kelly. Hope all the babies are good. Internet sleuth you are. Dude, I went down that rabbit hole. I went to Brittany's page. I went to her husband's page, which led me to the mother-in-law's page, which led me to the family trip photo album it was family trip to Chicago or something like that. And it had a whole bunch of pictures. And that is the only one that I could pinpoint for sure was Richard Allen and Kathy Allen. I think there were more people involved than just Richard Allen. I can't disagree with you. I can't. You know, maybe he was Bridge Guy and he's the one that led him down the hill to somebody else. And then maybe he left after that. Maybe he was just the guy to get him across the trestle. Like, I don't know. I honestly don't know anymore. I just don't know. So, can you get the photo of Alan with a ball cap when they were in Tennessee? So let me internet sleuth this here real quick. Richard Allen, Tennessee picture. Oh, that picture. Oh, yeah. Yeah. Hold on a minute. I have that somewhere, but hold on a minute. Yes, yes. I know. I didn't realize that was Tennessee, though. Okay, so let me... No, I better screenshot it. Oh, shit. Oh, sorry. Sorry, a potty mouth. Yes, yes. This was initially in a video of his wife's. That's what that initially was. Hold on a minute, guys. Let me screenshot these real quick. Perfect one. This one is the one we're going to go with. Save that to there. There. Okay. I didn't realize that was the picture you were wanting. So, I am so confused where my pages are. Hold on a second. I'm confusing myself, y'all. It's okay. Image file. Pictures, Delphi. This one. That right there. Okay, so this was in, wasn't that 2017, Ben? And that's Richard Allen next to both sketches. OMG. I am so impressed you could help the prosecution with that picture. I turned that picture in when I found it. I sat on it that night and trying to decide what to do. And I did turn that picture into prosecution. I did. Because I didn't know it was eating at me. So maybe 2018. Yes. But shortly after, like, come on, not long after. JLR took screenshots of the Facebooks of Kathy and Alan's mother. Yes. They're in his playlist. Yeah. I felt bad for her. Man, she face planted outside of court. I felt so bad for her. She didn't show back up in court for well, while I was there, she didn't show back up. I don't know if she ever did. Good, you had to do it. Well, like I said, I found the picture. It was probably midday when I found it. I was like, I don't know what to do because it really doesn't show his face. I have no proof. I can just show how I got to that picture. And I was like, what do I do? Thought of it, thought about it for the night, slept on it. Next morning, I turned it in. They never did use it, so they must not have thought it was useful at all. The ball cap does seem to resemble young guy with hooded eyes and nose. Okay. I see what you're saying. But would you mistake somebody with facial hair that's gray and turning gray as young, Mariska? I mean, I can see what you're saying about the resemblance with like the nose and the mouth and the eyes. But I mean, he's clearly got gray hair in his facial hair. So unless he was clean shaven that day, which we know he wasn't, or well, I guess I can't say we know he wasn't. So one has facial hair, one doesn't in the sketches. But for me, when I look at the bridge guy video, it looks like he has facial hair. Blair was 50 feet away when she saw him. Fair point. Fair point. So she might not have seen the facial hair. And I'm sure, but I wouldn't consider what'd she say his build was? Hold on, let me take this. Let me add this back to stage. Remove that. You guys got me on all kinds of. You guys are taking me down the rabbit hole tonight. Medium build. Would you guys classify? No, it's fine, Ben. I'd rather go down a rabbit hole and have to have a part 5. Like literally, let's talk this through. Let's figure it out. Like I said, I'm on the fence at this point. I'm about to hop off of it, but okay. So she saw Bridget, right? White. Okay, I can give her that. She said about 20. Like you said, she was 50 feet away. So he might have appeared younger. But I wouldn't classify Bridge Guy in that video as medium build. And she said he had brown curly hair. And Richard didn't have brown curly hair. I don't know. Yeah, stocky, right? Right? I wouldn't call that medium build. I would have said stocky. I mean, I get he had a thick jacket on, so maybe she thought, well, if he took the jacket and the sweatshirt off, he would be medium build. Like, you know what I mean? I don't know. It bugs me. I know that. I think Richard Allen was stocky. Yes, I agree. Hey, Grendel. He looks stocky in the video on the bridge. Exactly. So I wouldn't say medium build. Like, I don't know. Okay. Let's get back to what they're saying about this before I go down an even bigger rabbit hole with everybody tonight. So, sketch is not hearsay. Statement is not hearsay if the declarant testifies and is subject to cross-examination about a prior statement, and the statement is an identification of a person shortly after perceiving the person. The rule, shortly after perceiving the person. So is 6 years later shortly after? So I guess the sketch was shortly after. I don't know. The rule applies regardless of whether the identifying witness makes a positive in-court identification or not. Here, Blair identified Bridge Guy to law enforcement immediately and developed her sketch 3 days later. Blair's sketch is also admissible as an adoptive admission, a statement that is not hearsay when it is offered against an opposing party and is one the party manifested that it adopted or believed to be true. Fair point. That occurred here in April of 2019. The Indiana State Police released Blair's sketch to the public and declared this is the face of Bridge Guy. Blair's sketch is admissible under Indiana's common law too. Decades before Indiana adopted the rules of evidence, sketches were admissible if the eyewitness took the stand at trial. Didn't know that. Even if the sketch was inadmissible hearsay, Allen was still entitled to use it. State law does not have the last word on hearsay. And the rule must yield to the constitutional right to present a defense. When identity is crucial to the case, a defendant is entitled to defend on a claim of mistaken identity, and this right cannot be abridged through the application of arbitrary or disproportionate rules or the mechanistic application of otherwise rational rules. Excluding the sketch violated the Constitution. Here, the state concedes that Bridge Guy's identity was crucial to the case. If we can determine who Bridge Guy is, we can determine who killed Abby and Libby. Blair's sketch was crucial to Allen's defense of mistaken identity, and the judge's decision to exclude it was arbitrary and disproportionate to any legitimate government interest. The error was harmful under both the constitutional harmless error standard and Indiana's evidentiary standard. There is no dispute that the state's timeline depended upon 1, Blair seeing Allen on the bridge, and 2, Blair and Carbaugh seeing the same person. Those sketches are not the same person. Blair's sketch disproved both points. Excluding it affected Allen's substantial rights in the jury verdict. The court committed reversible error in excluding Tobin's testimony. Allen tendered William Tobin to explain the scientific community's robust criticism of the AFTE's toolmark matching methodology. The judge excluded him because he was not a firearms expert. He was untrained in firearms identification, and he did not examine the evidence in the case, and he did not conduct a firearms examination. According to the court, Tobin's testimony does not go to the issue before the jury and lacks relevance. I disagree with that, Judge Gull. I think you're an idiot, by the way, Gull. I think you're very biased. I seen you in court. You're very biased. This decision violated our rules of evidence and violated Allen's constitutional right to present a defense. Okay, hold on. Let me mark where I was there. Okay, expert testimony should be submitted if 1, the expert is qualified by knowledge, skill, experience, training, or education, and 2, the testimony will help the trier of fact to understand the evidence or to determine a fact in issue. Indiana adopted this rule to liberalize the admissions of expert opinion. Tobin was clearly qualified to explain the scientific community's robust criticism of the AFTE methodology. Tobin is a nationally recognized expert in forensic metallurgy and material science who has testified as an expert in many cases involving the validity and reliability of firearms and tool marks. He has extensive experience in metallurgy. I cannot say that word. Bullet and lead analysis and tool mark principles, along with a background in statistics. He understands the President's Council of Advisors on Science Technology, which has issued a detailed report criticizing the AFTE's methodology. Tobin's testimony was essential for assessing Oberg's credibility and determining what to believe. Once an expert takes the stand, their credibility is fair game for impeachment. I gotta laugh at that. I gotta stop. Okay, go. Go. Let me point this out to you, Miss Francis. Go. You're an idiot. Okay. First of all, this man is clearly an expert. Let's just leave it there. You're an idiot. However, you allowed an expert on the stand, right? You allowed prosecution to take a break, a 5-10 minute break. You allowed said expert to go out in the hallway and Google an answer to a question. Then you allowed that expert to come back in, get back on the stand, and testify, I just Googled the answer. Dude, seriously, girl? Really? Once an expert takes the stand, their credibility is fair game for impeachment. Experts don't have to go outside and Google answers. If you're a real expert, you know the answer because it's literally in the name. You're an expert. I need to hit comments for a minute because this one just, she pisses me off. He was kind of hunched over and not really walking upright. Correct. He was in the video. I think he may have been wearing the cap that he had on at the bar playing pool. Maybe. Very well possible. Hello, Seaweed. So Mariska says, this needs to be overturned and he needs to be released. They will not get a conviction with the evidence they have, and the defense has more than enough for reasonable doubt, in my opinion. They will owe him money. Okay, let me cut that down. Needs to be overturned. Yes. He needs a new trial. Now you said he needs to be released. He needs either released to like house arrest where he can't leave the house, or like maybe a mental health unit to help him kind of get back on track from being in solitary for so long. I don't know that I would want him released where he could just go back in the community. That might be my bias talking. He needs a new trial for sure. I agree with you there. The release, I would have to put conditions on the release. They will not get a conviction with the evidence they have. And the defense has more than enough for reasonable doubt. I agree. And I think that if this goes to the Supreme Court, which I fully expect that it will, I don't think the Indiana Appellate Court is going to overturn it. I think it's going to have to go to the Supreme Court. But I don't think that they would owe him money. The only way I can see them owing him money is if he were to get a civil rights lawyer and sue for all the rights that they violated. Patient-client, or doctor-patient privilege, attorney-client privilege, not keeping him safe, letting him hurt himself, the things that Dr. Walla did, as in destroying the notes and possibly feeding him information. And I would think that for them to owe him money, he's going to have to be found not guilty and then get a lawyer and sue, a civil rights lawyer. And what I don't know is if, let's say, Kathy Allen goes and gets a civil rights lawyer now, if they could sue while he's still there. I don't know. I would think the fact that they held him for 13 months in solitary confinement when the DOC says no more than 30 days in Indiana from mentally or serious mental illness, which he falls under, they could probably sue the prison right now. But if you sue the prison, I mean, he's not in Westville anymore. We looked at that the other night. He's out of state. I don't know. Yes, he will sue and he will get millions, in my opinion. I agree he needs to sue. I agree with that. I just don't know if doing that while you're currently convicted would be the best way. I think that he would need to, and like I said, I think this is more than likely going to go to the Supreme Court to be overturned. But I would think he would have to be out or found not guilty before he could sue. I don't know. Can prisoners sue the DOC? Like if they're currently incarcerated? I don't know if they can. I'd have to look that up. I would definitely have to look that one up. So, the jury is ultimately responsible for assessing witness credibility and determining what to believe. Yeah, well, you didn't give them that chance because you wouldn't let the defense put on an expert to correct the quote-unquote expert that you had that says an unfired round matches a fired round. Not possible. Here, Oberg testified that she matched tool marks on test firings, meaning she fired them from Allen's gun, with tool marks from the unspent cartridge found at the murder scene. Not possible. You're an idiot. Oberg told the jury she found agreement between the tool marks by using the AFTE methodology. In my opinion, proving that is wrong. Now, this is the same lady that earlier said, I've never made a mistake in 17 years. I find that doubtful. She gave an error rate of 2.2% for false positives and 2.87% for false negatives. She discussed studies and articles that she reviewed to apply the methodology, and over relevance objections, she described studies relating to guns that were not even Sig Sauer Model P239. A lay juror might find this testimony impressive and coherent, but AFTE's methodology is anything but straightforward. Tobin's experience would help a jury understand the scientific community's criticism of the AFTE's subjective methodology and force Oberg to engage with that critique. Even if our rules tolerated Tobin's exclusion, the decision was patently unconstitutional. A defendant is entitled to a meaningful opportunity to present a complete defense. Hey, Galt, do you know what that means? Because I do. This entitles him to impeach a witness who provides a crucial link in the proof of the defendant's guilt. Although trial courts possess broad discretion to limit impeachment, the discretion cannot be used to arbitrarily exclude competent, reliable evidence bearing on witness credibility when such evidence is central to the defendant's claim of innocence. Again, can we violate this man's rights any more than they already did? Here, Oberg's credibility was central to the case, and the judge arbitrarily excluded Tobin. Tobin is an expert in the AFTE methodology and its shortcomings. He is experienced with firearms identification, and he examined Oberg's materials. There was no legitimate state interest in excluding Tobin. Allen did not waive his right to appeal the Tobin issue by calling Warren, a party aggrieved by the erroneous evidentiary ruling, is entitled to respond to the proper ruling without sacrificing the right to appellate recourse. Ouch. Once the court excluded Tobin, Allen responded by calling Warren, who endorsed the use of the AFTE methodology and engaged Oberg in a battle of experts over how to properly apply the methodology to the evidence. The decision did not waive Allen's right to appeal Tobin's exclusion. The error was harmful under both the constitutional standard and the evidentiary standard. The state told the jury Oberg's never been wrong and that Allen has no explanation of how his bullet from his gun ended up between the bodies of Abby and Libby, 6 inches from Libby's foot. Had the jury heard Tobin's robust impeachment of Oberg's methodology, the outcome of this case would probably be different. They would have looked at it different for sure. He can only sue if they overturn the conviction and then find him innocent in the second trial. Yes, that's what I thought. That could be why he won't get a new trial if the state is worried they will be sued. I don't know. I feel like this initial appeal is going to be denied, and it's going to go to the Indiana Supreme Court, and they've already had to go to the Indiana Supreme Court, remember, because the attorneys were kicked off the case and they had to go to the Indiana Supreme Court. And the Indiana Supreme Court said, no, Gull, you can't do that. They're back on. So I feel like this is going to end up at the Supreme Court again. I think a good lawyer would put a hole in their evidence. I agree. In my opinion, they are lacking a lot of credibility evidence against Allen. I agree. But it wasn't that his lawyers were bad. His lawyers were told, you can't present a third-party defense. You can't present this expert that's federally recognized and nationally recognized. So, I mean, their hands were tied. They were trying to defend him with their hands tied behind their backs in a swimming contest. I mean, they were literally not able to do anything, essentially. The court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its entire case. The state built its entire case upon the following timeline. Allen encountered the girls at 2:13. He completed the murders alone, left Libby's phone at the murder scene, was spotted by Carball leaving the scene at 3:56, and never returned. If Allen committed the murders, there should be no human-initiated activity on Libby German's phone at 3:56 p.m., but there was. At trial, Allen called Eldridge, a former FBI forensic examiner who examined the data from Libby's phone and testified that wired headphones or an auxiliary cable were plugged into the phone at 5:45 on February 13th and then removed at 10:32 p.m. This action would silence a phone call, and she noted that the data showing an incoming call moments before the headphones were inserted, suggesting someone was intentionally silencing Libby's phone. Since the state claimed that Allen left the murder scene at 3:56, Eldridge's evidence eviscerated the state's timeline and showed someone else committed the murders. The state responded by asking Cecil, its phone expert, oh Lord, here we go again, whether water damage could simulate headphones being plugged into Libby German's phone. So let me remove some pictures here, because I'm going to show you Libby's phone at the crime scene. Give me just a second. Oh, which one do I want to use? We'll go with this one. So you can somewhat see Libby's phone here in the purple. This is the state's Exhibit 11. And you can see the phone screen black here. It's covered with leaves. It's in the shoe. This down here is the shoe. It's in the shoe. And this was under the body of Abby. Let me pull up this picture. And this is a closer view, different angle, and you can see the moisture on the screen, and you can see the phone a little bit better. You can see that it's been uncovered from the leaves a little bit. Yeah. Oh, Lord. Lord have mercy. Here we go. Can you see it? See it right there? Over a hearsay objection, Cecil testified he Googled it. They literally took a break so he could go outside and figure this out, and he Googled the answer. Defense says, objection, this is hearsay. Google's not an expert, essentially, right? So, overruled. He can say it. Cecil testified he Googled it and found some unspecified, non-peer-reviewed troubleshooting forums reporting that it could. This is an expert, y'all. This is who she thinks is an expert. This is who Gall said can be an expert. Cecil's testimony was inadmissible totem pole hearsay, unless our evidence rules provide otherwise. Out-of-court statements are not admissible for their truth. For totem pole hearsay to be admissible, each part of the combined statements must conform with an exception to the rule. Here, the posts in the troubleshooting forum are at least double hearsay, the internet forum and the statements posted there. Cecil's status as an expert does not affect the hearsay analysis. Statements contained in a reliable authority can be admitted over a hearsay objection when used to contradict an expert who is testifying on the witness stand. Hey, defense, can you fix your misspelling, please? It's right here. Okay. Y'all need spell check. But here, the online forum was neither reliable nor used to contradict Cecil. Rule 703 does not avail the state either. Under 703, experts may testify to opinions based on inadmissible evidence if the evidence is of the type reliable, relied upon by experts in the field. I'm pretty sure Google is not relied upon by experts in the field. I'm just saying. Yes, at this point, I'm getting snarky. Yeah, literally let Google be the expert, Judge Gull. You're an idiot. Sorry, guys. The rule, however, does not authorize experts to parrot facts that the expert adds nothing to. Cecil added nothing here. He was a mouthpiece for totem pole hearsay that he Googled. The error was constitutional. A defendant is entitled to a fair opportunity to defend against the state's accusations. Listen, Linda. Listen, Miss Gull. You're an idiot. I'll say it again. You literally let this man go outside. You took a break so this man could go outside the courtroom and Google the answer. And when it's objected to, you're like, nah, nope, we're letting it in. It's okay. This one gets me. That one has got me ever since it happened. Like this is one that just frustrates me so much. Oh, anyway, let's go to comments before I go completely AWOL and spill how I really feel about Gull. If the appeals court does not overturn this case, they are crooked as get out. Well, I can tell you, Indiana's crooked as get out. They're all corrupt. I'm sorry, they are. The United States Supreme Court will surely take this case and overturn it. 7,000 to 8,000 cases are presented to them every year. I think it's gonna end up in the Supreme Court, and they only accept about 150 per year. Not the expert went into the hallway on break. Oh, don't make me laugh, Grendel. It hurts. And Googled and then testified that the phone was turned on by dirt intermingled the power. Can't make this fucking shit up, right? I can't. This one pisses me off. It like really, really pisses me off. Because I live in Indiana. You set a very dangerous precedence that an attorney can say, can we have a break so he can go Google this answer real quick? You set a really, really dangerous precedent, Gull. Do you not understand that? Do you not understand what you've done with this case? You've made a mockery of Abby and Libby's case. And those babies deserve justice. And McClellan, you're a POS. You showed those girls mutilated, bloody, and nude bodies to a courtroom of people. But when it came to showing Alan's videos, oh no, public can't see that. We've got to respect his dignity. Where was your respect for Abby and Libby's dignity? Yes, it will. I'm sorry. I'm getting a bit pissed at this point. If it ends up going to the Supreme Court, it will be overturned. I agree. This is why they don't want the trial televised, right? That's like her using AI to write her decisions, right? I mean, come on. I'm sorry, guys. I went on a rant that it just really, and I'm not the only one that really ticked off. It was even said, I think during one of the impact statements, I believe Becky said it as well. Where was the dignity for the girls? You didn't You didn't care to show Libby naked and sprawled out and mutilated to the courtroom. But when it came to Rick Allen, you had to protect his dignity. And you're letting experts go Google answers. You made a mockery, Gall and McClelland, both of you, of this case. And it pisses me off to no end. Like it pisses me off to the point that I get emotional about it. And that's not a good point for me to be. Nor should anybody accept that. A complete mockery, exactly. Slick Nick, yep. And it was ridiculous. Like, I'm sorry, I went off on a rant. I'm sorry. But it just, you know, I don't know if you're in the United States and somebody says, well, Indiana versus Allen says I can do this. You have now set a precedence for this. Anybody can do it. Anybody can say it because you've allowed it now. And I hope to God it's overturned. And I tell you what, I'm almost to the point, not quite to the point that he's innocent, but I am to the point that when overturned, I hope they overturn it with prejudice, which means you can't retry his ass. I hope they take your search warrant. I hope they take all of it away from you, because that search warrant and everything thereafter is fruit of a poisonous tree and you can't use it. So you know what? Try again. Give me a second. Yeah, I need a cigarette. Sorry, I don't mean to go off. It just really, I can't stress enough how much it pisses me off what they did. You trampled every right this man had. Every single one of them. This includes the right to impeach a witness through cross-examination when they provide a crucial link to the defendant's guilt. Here, the judge arbitrarily allowed the state to undermine Eldridge's testimony with a person's internet post. And it's impossible for Allen to impeach the person through cross-examination. The error was harmful. Eldridge's testimony undermined the timeline upon which the state built its entire case. Allowing the state to rehabilitate the timeline affected Allen's substantial rights and the jury's decision. The court committed a reversible error by excluding evidence that impeached the credibility of Allen's confessions. At trial, Allen sought to impeach the credibility of his confessions. The judge made 3 reversible errors. Together, the decisions violated his constitutional right to present a defense. When the defendant confesses, the manner in which the confession was obtained is relevant to the confession's credibility. The court erred by excluding the audio from Allen's solitary confinement videos. At trial, Allen moved to introduce 15 videos showing the conditions he endured in solitary confinement, and the court sustained the state's hearsay objection and ordered Allen to mute the videos when they showed them to the jury. This was a reversible error. The audio shows a delusional, confused, and disorganized mind. The evidence can only be fully appreciated by listening to it, according to Allen. Accordingly, Allen respectfully requests the court to watch the videos with audio, especially, and then list the numbers. The statements in these videos are not hearsay. Statements are not hearsay when used to prove a defendant's state of mind. This was precisely Allen's purpose in offering the evidence, and the trial court conceded this. To the extent there are older cases suggesting that a defendant can never admit his own statements, though those decisions are inconsistent with and should not survive the adoption of the modern rules of evidence. The audio in the video is also relevant because it impeaches Dr. Wallace's testimony and undermines her medical records, which she destroyed, by the way. Wallace's evidence gave the misleading impression that Allen provided organized and detailed confessions with a beginning, middle, and end. Keep in mind, one of his confessions was he would never cheat on a cigarette again. But hey, he's in his right mind, right, Wallace? But the omitted audio rebuts this, showing disorganized, nonsensical, and confused Allen. On May 3rd, for example, Dr. Wallace describes Allen's mind as more organized than he'd been. But the April 28th video puts this statement in context, showing a disjointed, tangential, nonsensical, and rambling Allen. He is plainly psychotic and uncredible. The audio also presents a valid picture of solitary confinement's harsh conditions. Staff talked callously to Allen. Guards remark of how long feces is on his back. Inmates tell him to kill himself. A medical staff ignores obvious signs of serious mental illness and over-medication. Again, Dr. Wallace, you prescribed the medication, so how can you say, oh, he's over-medicated? Bitch, you prescribed it. In one video, medical personnel ask Allen about his cholesterol and blood pressure while ignoring his catatonia and drooling. Without the audio, this video presents a misleading impression that the medical professionals are attentive when in fact they are not. The error was harmful. The audio shows that Allen's statements in solitary confinement are unworthy of belief. Excluding them, therefore, affected his substantial rights and likely influenced the jury's decision. Look, we all want justice for Abby and Libby, but we want true justice for Abby and Libby, not some guy you railroaded. There's a difference. We want true justice, the real person who did it, the real person behind bars. And I'm not saying it's not Allen. I'm on the fence about that. But at least convict him fairly. Here is what's even worse. If this guy is innocent and the murderers are still out there, right? They are still out there. One may have already died, possibly, yes. But there's more than one and more than two, at least, in my opinion. I have to, even after they convicted Allen, we went to the press conference. We go over there, and the state police was asked, essentially, is the case closed now that you've got a conviction? He's like, well, no, we're still open to other evidence. Really? Really? But you swear he's the only person who did it, right? Make sense. You can't have your cake and eat it too. You can't talk out both sides of your mouth. I'm so aggravated with this case. I just want justice for Abby and Libby. Like I said, I just want true justice for Abby and Libby. No matter who it is. No matter how many it was. Abby and Libby deserve true justice. The trial court committed reversible error in prohibiting the jury from hearing two phone calls Allen made on April 3rd, 2023. On April 2nd, Allen called his mother and discussed finding religion. In the early morning hours of April 3rd, Allen made three intertwined calls. Over an objection, the jury heard the second call where Allen confessed to his wife, but the judge prohibited the jury from hearing the calls that bookended it. So this was the middle call that they used out of the three, where Allen questioned his sanity and the veracity of his own statements. Keep in mind, one of the quote unquote confessions was, "I think I did it. I might have done it. I don't know. I think I'm losing my mind." I would not call that a credible confession. Nor would I call when he says, if this gets too, he's in solitary for 5 months. At this point, he calls his wife and he's like, "Hey, if this gets to be too much for you, call the detectives. I'll tell them whatever they want to know. I killed Abby and Lemmy." Now, let me see what you guys, these are quote unquote reliable confessions, right? So let me go back to, nope, not there. Right there, right there. I know I have it. Where is it? All files. Maybe that's what yes, there it is. Okay. This is a recreation. Maybe. Image file. Why are you not doing what I want you to do, computer? Open. Okay, it's not going to let me show it for some reason. Let me remove that. Image file. Come on, you piece of crap. If I have to, I'll open it in another window. Okay, invalid image type. Okay. So hold on a minute. Let me open this in a different file. And then let me stop screen, share screen, window. Don't have there. Does that look like normal to you? Is that how you would write if you're coherent in your right mind? No. This is a recreation. One of the media people recreated it from looking at the evidence because they weren't allowed to take pictures, so she drew a recreation of it. And he said, "I'm ready to officially confess killing Abby and Libby." And then his signature is weirdly in the middle of all that and not at the end. And then it says, "I hope I get the opportunity to tell the families I'm sorry." Listen, this is not in his right mind. He's not. And if you think he is, then maybe you need your mind checked. Just saying. So let me share screen again. Okay. So I had to show that because he's not in his right mind at all. So Trooper Harshman's testimony made the error even worse. Over objection, Harshman claimed that when confessing, Allen was consistently calm, subdued, and solemn in tone, showing no indication of duress and stress. Bullshit. But the excluded April 3rd calls discredit this testimony. Allen was confused and forgetful in those he believed he was losing his mind and that the Indiana Department of Corrections was poisoning him. He referred to being mentally tortured, compared his environment to Guantanamo Bay. Independently, this error was harmful and warrants reversal. In closing, the prosecutor told the jury Allen started confessing on April 3rd because he'd given himself to Jesus the day before. The excluded April 3rd calls tell a different story. Allen was losing his mind, showing lapses in memory, and confusing dreams with reality. The prosecutor got to offer an inculpatory story for how the confession started, while Allen was prohibited from presenting an exculpatory story through contemporaneous evidence. Again, you took away his right to defend himself. Let me go back over here. Yes, Grindel is a jerk at this point. He's got me sitting on the fence, and I don't like it. I don't think I got it right. I have to watch again and try again. Be right back. Okay. Well, not my fault. I was born so smart. I think it was know it all is what I was called. I was called a smart ass. That's what I was called. So let's continue here. We are on page 100 of 113. I doubt we finish all of them. We're gonna have to end up having a part 5 because I went off on a tangent. Sorry. The trial court erred by excluding the statements and behaviors that provided the foundation for Dr. Gracian's opinion that Allen's confessions were not credible. At trial, Dr. Gracian testified that Allen suffered from delirium, but the judge prohibited Dr. Gracian from discussing the statements that provided the foundation for this opinion, including Allen's statements that were patently false. This was a reversible error. First, Allen's false statements were not hearsay. At one point, he said he shot the girls. Clearly false. Their throats were cut. He offered the statements to show his state of mind and prove that he was saying things unworthy of belief. Second, even if hearsay, the statements were admissible under Evidence Rule 703, which provides experts may testify to opinions based on inadmissible evidence, provided that it is of the type reasonably relied upon by experts in the field. And third, the statements were admissible because the state opened the door 3 times. They sure did. They kicked that door open. Trooper Harshman testified that Allen's confessions were consistent with the facts and included details only the killer would know. Remember there, Harshman, he also said in one of them that he shot him. So where is that a detail that is fact? And where is that something only the killer would know since they weren't shot? Serious question, Harshman. I've got questions. The state also paraded witnesses before the jury who opined that Allen's mind was intact when he confessed and he was faking his symptoms. And Dr. Walla testified she saw no reason to screen Allen for delirium. Allen was entitled to counter all of this with evidence, but his statements were false, inconsistent with the murder scene, and consistent with delirium. Independently, this error was harmful and warrants reversal. In closing, the prosecutor molded a story that depicted Allen's undisputed psychosis. His confessions were truthful. The judge affected the jury's decision when she prohibited Allen from showing that he made repeatedly untruthful confessions. Together, the above 3 errors violated the Constitution. The Constitution prohibits a court from stripping a defendant of the power to describe to the jury the circumstances that prompted his confession. That is precisely what occurred here. Allen repeatedly presented evidence that placed his confessions into context and impeached their credibility, but the judge arbitrarily excluded the evidence and disproportionately ruled in the state's favor. You sure did, Gull. You sure did. The trial court committed reversible error in denying Allen's court motion to correct errors. Allen timely filed a motion to correct errors, arguing the state elicited false testimony and allowed it to go uncorrected. The trial court denied the motion. The 14th Amendment is violated when the prosecution knowingly solicits false testimony and knowingly allows it to go uncorrected. According to Dr. Walla, Allen confessed that he was attempting to rape the girls, but abandoned his efforts and fled with them across the creek when he saw a van. At trial, the state elicited testimony from Brad Weber, who told the jury he left work at the Subaru factory in Lafayette, Indiana around 2:02. On February 13th, he drove his white cargo van directly home. The prosecutor told the jury that the timeline of Weber's testimony, Allen's confession, and the step data on Libby's phone matched perfectly and proved Allen guilty. Not really. If you look at the health app data, there's a pause in the movement for 7 minutes. He has 7 minutes with them. But before he can finish his deed or his deeds, he sees a van. Brad Weber's coming home from work down his private drive to his home, and he scares Richard Allen. Then Richard Allen forces the girls across the creek to a spot in the woods, a secluded spot, and he kills them, and he cuts their necks. Weber's testimony was false, and the state knew it, specifically security camera footage from Weber's neighbor showing him arriving home at 2:44. And the FBI report showed Weber's cell phone arriving home around 2:50. And let me see if it will allow me to do it. Yep. This is, you can't really see it very well. 2:44:37. Right here's the white van. 2:44:37. Right there's the white van. 2:44:38. Right there's the white van. Now, these are stills taken from the video itself. So, yeah. So let me go. See, I'm behind in chat, so let's catch up here real quick. Oh, wait, you're referring to that comment there. Okay, that was... Oh, Lord. But how many times did he confess? It was a lot. Yes. 60-something times, but all within like a 2 or 3 month period when he was going through psychosis. Some of them were before they diagnosed the psychosis, some of them after. I'm not saying they're all out, but if you're going to say, well, this confession on the 3rd is correct and he's normal, but the phone call right after that is, I don't know if I called you or if that was a dream. Seriously? You can't have your cake and eat it too. Like, if you're going to show the confessions, then let the defense be able to say, well, he also said he wouldn't cheat on a cigarette in this one. On this one, he thinks he's king something or other. I mean, let them all win. Let the jury fairly determine what they think is correct. That is the point I'm making on that. The guy was doing the Haldol shuffle his way into court every day, being handed off from one cop to another just to keep him up stable, right? The man was on, like, they don't give Haldol for little stuff. Like, that's a major drug. So many things wrong with this case. He confessed to anyone and everyone who would listen, yes. And all of those confessions came after he said to his wife, if I remember correctly, that if this gets to be too much, call the detectives and I'll tell them whatever they want to know. Shortly thereafter is when the confessions started. He had already been in solitary confinement 4 to 5 months at that point, and he had serious mental illness and was not supposed to be in there more than 30 days. They weren't credible. There were so many false things in them. Exactly. One of them, like I said, he's like, I shot the girls. No, you didn't. Their necks were cut. Abby's was cut once. Libby's multiple. I don't think handwriting is a determination of mental health. Sorry, but I don't think it's a huge factor. It's not necessarily, you're missing what I'm saying. It's not necessarily the handwriting, it's the wording, the handwriting, the ability to follow directions. It's the whole thing as a total, right? It doesn't make any sense. And again, his signature is in a really weird spot, almost as if somebody said, "Hey, sign this," right there. And then they went over and wrote it, because I don't know how to explain it to you correctly, like how I'm thinking it, but it doesn't make a lot of sense. I feel like it was almost, like I said, as if somebody said, "Hey, sign here," and then wrote in the rest. Exactly. Was Alan seen on the same video camera either arriving or leaving? Yes. Alan was seen on the Harvest Store camera entering and going to the CPS building, but I don't remember what time that was at. I'd have to go back and look. And I think he was seen leaving on that camera as well. I would have to go back and get the times. He was caught on camera, but not that camera that they seen the white van on. While highly over-medicated. Exactly. That's, I think, the point that I'm getting to. He's highly over-medicated, and he's writing this discombobulated confession to the warden. It's like, that's what, it just doesn't make sense. They have the car arriving, but it's debatable if it's Alan's car. Yes. Yes. And that was on the Harvest Store video. I think 127. That's what I thought, but I wasn't. I couldn't remember for sure, so I didn't want to state misinformation, but that's what I thought. It was around 127. Because remember, he initially said he was on the trail from 1:30 to 3, and his car was seen going by the Harvest Store at 127. He parks at the CPS building. That gives him approximately 3 minutes to walk onto the trail. Thus, he had enough time to be there from 1:30 to 3. Instead of I was leaving by 1:30. So there are just too many things, and I'm trying to remember everything, and I just can't remember every single little detail, but I'm trying. But I also don't want to give out false information. So that's why I didn't state an exact time. But yes, they did see him arriving on the Hoosier Harvest Store camera. The error was constitutional and requires reversal. An error requires reversal if it could have contributed to the verdict, which it did, in my opinion. But it's not did, but could have. Here the false evidence is, if corrected, would shown that Weber's arrival at home was inconsistent with the state's murder timeline. He arrived home 25 minutes after the pause in movement in Libby's phone, and nearly 15 minutes after Libby's phone was on the other side of the creek and hundreds of yards away from Weber's home. Thus, Allen's statements to Walla are inconsistent with the truth and suggest he was delirious. The error requires reversal. What was the timestamp? So I would have to go back and look at that, because I don't remember. Mariska, I just don't remember. I would have to go back and look. I'm trying to think. I want to say it was, but that can't be right because that doesn't match the evidence. I wanted to say 107 or 207, but that doesn't match the evidence. So honestly, I don't remember. I would have to go back and look. Sarah Carbaugh is the witness who saw him leaving allegedly. Yes. And she first described him as wearing a tan jacket and being muddy. Then later it was a blue jacket and muddy and bloody. Mariska 213. Okay. Well, I wasn't far off. Okay. Thank you, Ben. I can always count on him to have it if I don't. My God, we covered this trial for so long. I should know all of these by heart. So let's go a little bit further. We've been here 2 hours. Let's see if we can't go a little bit further. If you guys get tired of listening to me ramble, we'll end it. The trial court committed reversible error when it excluded Allen's evidence explaining the murder as a ritual killing. The trial court prohibited Allen from explaining the murder scene as a ritual killing. This was a reversible error. Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime and thus meets the definition of relevance in Rule 401. Here, Allen tendered that Don Perlmutter, a recognized expert in ritualistic killings and atypical homicides, to explain the elements of ritual killings. Ritual killings, honey. Defense, fix it. It's supposed to be ritual killings, not rituals killings. Commonly occur outdoors in wooded areas and near bodies of water. They occur on holidays significant to the group and commonly often involve the use of ceremonial knives. There will be symbolism at the scene in the Norse pagan rituals. The symbolism will likely involve runes, arranging natural objects in a specific way, and perhaps combining the runes with blood, i.e., blooding the runes. You don't get bullet wounds with ritual murders. Rather, there is usually throat slitting, blood loss, and perhaps torture. I don't know. That sounds pretty close to what you did. You would expect the sacrifice to be displayed or arranged at the scene in a manner that is significant to the group. And finally, you would expect to see an atypical or symbolic blood pattern at the ritual killing. I don't remember which part we were in, but we talked more about the ritual killing and the date. I don't know if they will go into it again or not. They very well might, though. According to Perlmutter, the murder scene included all of these elements. The murders occurred outdoors in a clearing and near a large creek. The murderers coincided with the Nordic holiday, which honors Odin's son. The girls' throats were cut with a knife and they bled extensively. Perlmutter found the sticks to be obvious symbolism and difficult to explain in any other way. In her opinion, the stick arrangement on Abby mirrored the Norse rune Gibo, and the stick formation on Libby looked like the Nordic bind rune. Perlmutter also explained that the bodies were arranged in a manner consistent with the pagan ritual. An upside-down hanging body is an important element of Norse paganism because Odin hung from a tree for 9 days before discovering runes, and Odin's leg is often displayed with one leg bent behind the other. Here, the blood patterns on the girls' faces suggested a person lifted their bodies and articulated their torsos and necks above their chins. Abby's leg was bent behind the other, mirroring the classic image of Odin. And the blood pattern on the tree appeared to look like a Norse pagan Fuhu run. Perlmutter had the knowledge, skill, and experience to offer this testimony. Expert testimony should be admitted if 1, the expert is qualified by knowledge, skill, experience, training, or education, and 2, the testimony will help the trier of fact understand the evidence or determine a fact in issue. In Evidence Rule 702, here Perlmutter is an expert in ritualistic killings and a recognized federal subject matter expert on atypical homicides and ritualistic crime scene investigation. And she is the author of Ritualistic Crime Scene Investigation, a field guide for law enforcement officers investigating ritually motivated crimes. She teaches about ideological and ritualistic killings, and she is familiar with the practice of Norse paganism or Odinism. She is qualified to offer her testimony. Perlmutter's testimony is not conjecture. There was always a discussion among law enforcement that this may be a ritual murder and that the sticks were Nordic runes. The BAU declined to exclude pagan ritual as a plausible explanation for the murder scene. A consulting professor who is from Purdue found it quite plausible. The stick markings constitute an instruction inspired by Norse runes, a modern recreation thereof. And the undercover law enforcement officer familiar with the runes also found pagan symbols at the scene. Perlmutter's testimony would be helpful to the jury, although motive is not an element of murder. Juries want an explanation for the crime, and when motive is unclear or inconsistent with the defendant's guilt, juries are more likely to acquit. Similarly, when a murder scene is complex or unusual, it is important for the jury to receive an explanation. Here, the murder scene was complex and unusual. Remember, it has many tentacles, and the jury would naturally want an explanation. The sticks immediately stand out to any rational person as unusual and warranting an explanation. Perlmutter's testimony provides an answer. It explains the scene and offers a motive. Her testimony would be helpful to the jury. Excluding Perlmutter's violated the Constitution. A defendant is entitled to answer the prosecution's case with his version of facts, so the jury may decide where the truth lies. Now, remember, he was prohibited from bringing up paganism or Odinism or any third-party defense. So they violated his rights more than once on this issue. And the judge cannot infringe upon this right through the arbitrary, disproportionate, or mechanist, I can't pronounce it right now, application of the rules of evidence. But she did. Accordingly, if the state offers an inculpatory explanation for the evidence, trial courts cannot use the rules of evidence to prohibit the defendant from offering an exculpatory explanation. By excluding Perlmutter's testimony, the trial court allowed the state to offer an inculpatory explanation for the murder scene while denying Allen his constitutional right to offer an exculpatory explanation. This arbitrarily and disproportionately denied Allen his constitutional right to present a defense. The error was not harmless. The state told the jury repeatedly this case was about a brutal murder, and it explained the evidence in a manner that incriminated Allen. The jury received a one-sided explanation for the crime without Allen being able to counter it. The error affected Allen's substantial rights and altered the jury's decision. Fair enough. Okay, let me go catch up. Oh my, I'm way behind in chat. What was the black car leaving on camera passing the cemetery? I think it was. I think they tried to say that was Allen, but I don't know that was ever confirmed. That wasn't confirmed his either, I don't think. Yeah, I didn't think so. I don't think the colors matched. Nope. Halidol is an antipsychotic, yes. It will make him tired, but he wouldn't be hallucinating on it because that's the purpose of the medication, to take away hallucinations. And it did take away the hallucinations. They were forcefully giving it to him, and it did take away the hallucinations. Who did the knife belong to? We don't know. So the expert that came in and said he thought it might have been a box cutter because he was in his garage working one day and realized it had a scalloped edge or something like that. So he thought it could be a box cutter. But one of the third party people that could have been involved had a bunch of ceremonial knives that were never tested. So we don't know who owned the knife. They never found the knife either, Cheryl, that had the girls' blood on it. For all we know, it got thrown in the creek. I think she's talking, Mariska, about the knife that cut the girls' throat. They never found the murder weapon. That is correct. Peace Spice, that is not true. One, medications affect people differently, but this is why I would love to get my hands on his medical records while in prison before his trial to see how much he was being prescribed and being given him. I would love to know that as well. But they did say that his hallucinations stopped, Grendel, after being involuntarily medicated. But he's being involuntarily medicated, but then they're also saying he's over medicated. You're the one that prescribed it, bitch. Like, hello. Just over medicating with Tylenol would most certainly cause hallucinations. The F tree, yes, the F tree. And let's not forget, they had to go back weeks later and collect the sticks that were on the girls because at first they had no evidentiary value, even though it's something that both the killer and the victims would have touched. Let's not forget about the Facebook pictures on somebody's Facebook page depicting the crime scene and positioning the girls exactly. Yes. That was Holder, was it not? I believe it was. It was either Holder or Westfall. Had pictures on their face. I think it was Holder. Like 98% it was Holder. But here, let me just read it. Let me control F this. And let me type in Facebook. Social media. Yes. So, winners found concerning similarities between the murders and pictures posted on Holder's social media. Those pictures depicted young girls believed to be deceased with sticks over their bodies. So, that's who. That answers your question there, Mariska. It was supposedly from Brad Holder's Facebook, although I'm not sure it was proven. I have seen the pictures. I don't know if I got screenshots back then, but I do remember seeing the Facebook. Somebody had posted them, and I remember seeing them, and I went, eerily similar. Like it really was very eerily similar to the crime scene. Holder's son was friends with Abby. Yes. Murder weapons. Yes. Ben. Wow. I'm thinking they were involved. Right. Now, Holder and Westfall and Elvis Fields were possible third party people, and along with Ron Logan, who went to, I forget who he went to now, to get an alibi before an alibi was even knew that it was needed. So yeah. We'll just leave that there. That was the prosecution theory that Judge Gall excluded from the trial. Yep, that was his third party defense along with Odinism. Yep. And Gall said, nope, not at this trial. Not allowed to present any third party evidence. Any. Period. And keep in mind that the county kicked out the FBI because the FBI thought it could be related to Odinism. Winters also noted similarity between the stick formation on Abby and a bind run Holder tattooed or drew over his hand. That's a bind tattoo on my hand, said Holder. Basically, I took a Gibo run and an Iso run and I made a bind run. Holder's social media also featured him holding guns and homemade knives. Winters immediately recommended to his supervisors that law enforcement investigate Holder further, which they declined to do, claiming his alibi was cleared by the FBI. In 2018, Holder displayed a painting he made of Odin upside down with his right leg tucked behind his left, just like Abby's legs were. Holder's painting also featured the red Boo-hoo run, the F tree run. Winters was not satisfied and urged the Indiana State Police to conduct its own investigation, and no further action was taken. In September of 2022, the state charged Allen. At Allen's insistence, law enforcement re-examined Holder, and Holder's story about Abby began to change. Back in 2017, he told law enforcement that he had never actually met Abby. But in August of 23, he told law enforcement he met Abby once. And during a deposition in 2024, Holder said that he had met Abby twice. At least one of those encounters occurred shortly before Abby's murder at the West Falls home. On April 4th, Allen's counsel deposed Case and the Liberty landfill HR officer and found that Holder did not have exclusive control of his employee badge on the day that the girls went missing. Allen also uncovered evidence that impeached the course of the investigation even further. In 2018, Holder told his wife he had a fight with Westfall because Westfall wanted to up from animal slaughter to a different type of sacrifice. Holder then told her that Westfall killed Abby Williams with others and that she needed to keep her mouth shut about it. The evidence showed a shoddy, incomplete, and mishandled investigation into this murder as a ritual killing and raises reasonable doubt that Holder and Westfall were responsible for the murders. Allen was entitled to present this defense to the jury, and the judge committed reversible error by excluding it. The error violated the Constitution and affected the jury's decision. The Constitution entitles a defendant to attack not only the probative value of crucial physical evidence and the circumstances in which it is found, but the thoroughness and even the good faith of the investigation as well. And here, the omitted evidence created reasonable doubt and raised questions of the utmost importance about the manner, quality, and thoroughness of the investigation that led to Allen's arrest 5.5 years after the murders. Had the jury heard it, a different result was likely. Oh, we're getting there. We're going to finish it tonight. So, in conclusion, the very premise of our adversary system of criminal justice is that partisan advocacy on both sides of the case will best promote the ultimate objective that the guilty be convicted and the innocent go free. Because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. The appellant, Richard Allen, requests this court to reverse his convictions. And this is the verified word count. I verify that the appellate's brief includes footnotes containing no more than 24,000 words, according to the word count function on Microsoft Word processing program used to prepare the appellate's brief. Okay, if you use Microsoft Word, y'all need to start using the spell check on there, okay? So, certificate of service, I hereby certify that the true copy of the foregoing has been delivered through e-service using the Indiana e-filing service to Ellen and Angela, Deputy Attorney Generals of Indiana, the 17th day of December 2025. And we have reached the end of this, thank God, because I don't know that I can afford another me going on a tangent. Just put it that way. They so make me mad. Yes, that is what they excluded from trial. How many errors so far? Too many to count. Exactly. The case is bonkers. I agree. They made many, many errors. How will the appeals court defend these errors? They cannot do it and must overturn this fiasco. I agree, but I really don't feel like they're going to. I feel like they're going to stand by Gall. I don't know. My gut tells me they're not going to overturn this, that they're going to have to go to the Supreme Courts. Thank you for reading it, Melissa. I don't think anyone else read it all. I don't know if they did, but we still have a couple pages in the state's response to this to go. I might do that tomorrow, but it's like this has changed my mind. I have went from guilty. You're not changing my mind. I'm stonewalled. I'm not changing it. There's nothing that can convince me he's not guilty. To I am sitting on the fence and leaning towards innocent. And I hate that they have violated so many rights, because I've said it once, I've said it 1,000 times. They have set a very dangerous precedent of violating rights in this case. This should be a mistrial. I agree. Melissa is worth her weight in gold. Thank you all. Thank you guys. So we are done with that. Let me put up a picture, because this is what it's all about. Let me find the picture I want. I have so many of them. God, these girls were so funny. Little goofballs they were. I don't know which picture I want to put up. We'll put up this one. No, that one's all Libby. Gosh, guys, you know what? Let's put up this one. Those two beautiful little girls right there, ages 13 and 14, Abby and Libby, deserve justice. I don't care who you are. If it's not true justice, it's not real. And they deserve real justice. Has the prosecution given their response? Yes. So I have, let me open it up. Maybe if my computer will let me here. So I went over part of it before. Is this the right one? Yes. So we got to page, like, I have to go back. I have another video I did with Shar, going over most of it. I need to go over the rest of it. I need to go back to that live and find out where we left off and continue reading the rest of it. But let me see here. Let me show you this. So harmless, if I could spell. Error. 9 times. The state said harmless error 9 times in a 94-page brief. It's a harmless error. It's a harmless error. Let me remove the girls for a minute. You can see. Oh, you can't see it up here. Oh, well, that stinks. Oh, it's not even showing the right. Hold on. Stop screen. No wonder it wasn't showing it. Share screen. Window. Okay, you still can't see it because it's right here. But it says harmless error 9 times. in this brief. And I want to say we got to page 70 or maybe it was 50. But okay, so we've read through that. So the statement of issues for the state was whether the admission of evidence seized from Allen's home constituted a fundamental error. These are the points that the 4 points that they went on. Whether the trial court properly admitted Allen's confessions, whether the trial court properly excluded and admitted various pieces of evidence, and whether or not the trial court properly denied Allen's motion to correct error. So, like I said, we did most of this, and it's when I was doing this live on the state's response that I got Allen's actual appeal. So I decided to switch over the next day, and we did that. And so this is part 4 of that. And then I need to go back to the state's response video and mark it as part 1, and then pick up where we left off and do a part 2 of it and finish going through it. And then what I want to do, if I can, I don't know if I'm going to be able to do it, but I want to take and I want to put the state response, like stagger them either side by side or stagger them as far as this is what the defense says and this is what the state says, but I feel like that's going to be too long. So I don't know how to do it, but I'm definitely going to look at that trial transcript. We may end up doing some lives on that. We'll just see. So let me, yes. So Allen's lawyers filed for an oversized brief. Yes. Reply to the state's reply. Yes, it was granted. And the due date is April 23rd. Correct. Because they wanted to go over 12,000 words. You're welcome, Amy. Thank you, everybody, for being here and listening to me go off about this case. Ben, so the state has already given their response. Yes. So, Mariska, what is on screen right now is the state's response. And this is the state's brief to the appealee. So, I've already done a portion of this. I think it was me and Shar. So, if you go back in the videos, I think it's in the Delphi section. If not, it was several days ago. You can go and we have it marked the state's response. We didn't get through all of it. I've got to go back and look, but you can go watch that one if you haven't already. They are beautiful girls. So precious. Those babies did not deserve this word. No, they did not. I do believe they are in heaven with our Savior. Amen to that. Bless them both. Yes. So the colors that were around the courthouse on every post was the blue and teal. I think I have a picture. Let me look here. Where would that be? Pictures and go to Delphi because yes, there it is. I took pictures at here. We'll just go through some pictures. No, we won't. Not today. We'll go through pictures another day. So this was tied. These ribbons were tied all around. Every post had this on it. Teal and purple, which were the girls' favorite colors. So I have been on for 2.5 hours, but we got through Richard's initial appeal. I've already done most of the states. I'll go back, like I said, I'll go back and look and see where we left off. Maybe tomorrow I'll finish the state's response. And then I will look at the trial transcript and see. I'm not going to, I don't know about doing 23 days of trial. But I'll look at it. Maybe I'll pick out some important things. You guys could message me or comment on the video, on one of the videos, and let me know what you would like me to focus on when it comes to what was testified to at trial. We can do it that way. It's such a shame their lives were taken from them. Exactly. Root says those ribbons are very pretty. Yes. And I went back. I think it was in August. And a lot of the ribbons were still there. They're very faded now, but the ribbons were still there months later after the trial. So, let's see. Remove that. I don't know what I'm doing here. Okay. So I will see you guys later. Thank you for coming and hanging out. And hey, at least we made it through the appeal, and most of the states reply to it. Like I said, if you haven't watched it, go watch it. And we will finish that in another live stream. So we will talk to you later.
No amount of time will make us stray. We'll keep searching through the darkest day for every soul that's lost or gone. We'll fight until the break of dawn. American justice stands so tall. We won't rest until we found you. For all the lost, both the near and far, you're in our hearts. You're who we are. Through the nights and through the pain, we will say your name again. Every step we take is true as we continue to search for you. American justice stands so tall. We won't rest until there is justice for all. For all the lost, both the near and far, you're in our hearts. You're who we are. We will continue to pray until you're home.